Cameron is in downstairs. He's downstairs. Oh shoot, that's what I'm downstairs. You don't got a phone, right? Oh. And you know how to get a phone. He used to work in the courtroom. This is, it's like your cousin. Yeah, but that's the co-defendant of the Conley case. Of the Conleys? Yeah. So we need the file and then he's downstairs. Yeah. Can we go get the Conley file? And then, once you do that, then we can get the Conley. Yes, please. This is the state of Michigan versus Karia Lazan 25-01697. Have your appearances, please.
Thank you, Your Honor. May it please the court. Assistant Prosecuting Attorney Dan Smith appear on behalf of the people of the state of Michigan. Assistant Public Defender Joseph Hardy appearing on behalf of Mr. Lazan, who's making her way to the podium. I also have some paperwork for the court.
Okay, Ms. Lazan was scheduled today, final pre-trial. Excuse me, this is for an assault and battery. It says that she's going to plead no contest to count one. Killebrew agreement of no upfront jail. Is that accurate?
Yes, that's the people's understanding of the plea, and it's our understanding the defendant has accepted that. That is correct, Your Honor.
What is the purpose of the no contest plea?
At the time of the incident, she was suffering from an episode. She's diagnosed schizophrenic, and as a result, she has no memory of the incident as a result of her diagnosis and her mental condition at the time.
You have a highlighted police report from my review.
Highlighted, no, I was sending over the police report. No. Apologies.
You're sitting it over now, you said?
Yes.
Ma'am, you can have a seat.
It's the people's understanding based on the facts in the police report that the defendant was intoxicated and not necessarily suffering from a mental condition. But I believe the court can make that determination.
Thank you. I'll go off the record until we receive the police report on this file, but you can stay right there for now.
There you go.
This is the state of Michigan versus Nakira Roper 26-00910. Parents group.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan. Assistant Public Defender Joseph Hardy appearing on behalf of Ms. Roper, who's making her way to the podium.
Ms. Roper was scheduled today for final pre-trial for malicious destruction of the building, and then there was a domestic violence. How are we proceeding?
Your Honor, the people have attempted to make the contact with the complaining witness in this case. We have sent out multiple subpoenas. I've reached out to him personally. We've been able to get in contact with him. So at this time, the people are moved to dismiss this case. No objections.
Motion to dismiss is granted without prejudice. So that means the people have the right to reissue this against you. Do you understand that? I can't hear you. Yes. Do you have any questions? Okay, we'll get you a copy of dismissal in just a moment, okay? She's not on tether, is she? Are you on GPS tether? Okay, we'll notify them so you can go and have that removed, okay? Okay, thank you. You're welcome. Okay, state of Michigan versus Jana Wallace, 26-00492, appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Your Honor, David Udo on behalf of Jana Wallace, who is present and making the way up to the table.
Today was the date scheduled for final pre-trial for an extortion charge. I believe that there was some negotiations and a possible diversion offer. How are we proceeding?
Yes, Your Honor, at this time, the people are asking that this matter be adjourned and we have one more final pretrial. I believe I just received some additional exculpatory evidence from the defense counsel. I need to review that evidence and speak with the complaining witness. Once we've made or once we've been able to agree on the level of this exculpatory evidence, we may be able to get rid of this case. So at this time, we're asking for another final.
Is the complaining witness here?
He's not here. He did appear for the first appearance. So I just need one more opportunity to reach back out to.
And no objection from defense, Your Honor.
Huh? Yeah, it's already, it's 23rd.
Yeah, not next today, we'll kind of return, we did 16.
This is not something you believe you're going to trial on, is that correct?
I believe we're going to resolve one way or another, Your
We
Honor.
can convert the June 23rd date to another final plea trial. It's already scheduled for jury trial that date.
I have the day open, so thank you, Your Honor.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
Thank you. Haven't received.
So
I'll send you a copy.
we don't, yeah, we. So.
What's your name, sir, on the iPhone?
Excuse me?
What is your name?
Oh, Daryl Anderson.
I'll get you more.
Okay.
Thank you.
You make a copy of that for that young lady. Okay, back on the record. In the matter of State of Michigan versus Karia Lazan. The police report now, and we're ready to proceed with a no contest plea, is that correct?
That's correct, Your Honor.
And you want to plead no contest, ma'am? Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Okay, you understand that you have the right in this matter to proceed to a jury trial, and you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You also have the right to see, hear, or question in court any of the witnesses called to testify against you by the prosecution. You have the right to have witnesses subpoenaed to testify on your behalf, and the right to remain silent at any trial, and they can't use the silence to prove or imply that you're guilty. Do you understand that? Okay, and you want to waive those rights today in order to plead guilty or plead no contest, that is?
So all of the rights will be waived.
Yeah, you would have to waive each of those rights if you wanted to enter a no contest, but you understand that? And that's what you want to do? Okay, is anyone promising you anything to get you to waive those rights? Has there been any threats or inducements to get you to waive those rights? Are you currently on probation or on parole?
No.
You understand that by pleading no contest, a conviction could enter that could result in a conviction that you might need to report to a current or future employer. It also could have impact on where you could potentially travel or get immigration status. You understand that? Okay. And you don't remember the incident? Okay. Excuse me. This is a visitation. As to the assault and battery, how do you plead? I can't hear you.
None.
Have a police report here. No contest? Okay. Have a police report here from the Lansing Police Department, case number 2551903-206 from April 17, 2025 at 6:15 a.m. On or about that date or time at the address of 1215 East Michigan Ave, which is also the Sparrow Hospital, states here that Nurse Erica Allen was told by sitter in room 87 that the patient, identified as Karia Lazan, was urinating on the floor, and that the patient, Lazan, went to the, as Allen said that Lazan was her patient and she went to the room to figure out what was going on. Allen said Lazan was standing up and trying to get out of the room. Allen stated she was at the doorway. Lazan was trying to hit her. Lazan grabbed Allen's hair and pulled some of it out. Any additional factual basis?
Nothing from the people, Your Honor. Not from the defense, Your Honor.
Report does not one way or the other indicate the mental capacity or the condition as it relates to the defendant at the time. I'll take the prosecution's word for it that she was or suffered from some mental breakdown that caused her to have a lack of memory. Likely she was also intoxicated. I don't know why she was in the hospital, but I find the reason for no contest plea to be appropriate. I accept your plea, and a conviction will be sustained by way of no contest plea. We have your victim.
Yes.
Did your victim intend to give an impact statement today?
No.
So that she's free? Sentencing is scheduled for July 21st at 9 a.m. She'll go down and check in with probation before she leaves here so they can get her prepared for a pre-sentence interview. And they'll provide the court with a recommendation as to how she should be
Thank you, Your Honor.
sentenced. Any additional matters for the
Nothing from the
record?
people, Your Honor. No, Your Honor.
You're all set, man. State of Michigan versus Cameron Conley Embry, 26-01362 FY. Your appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Strauss on behalf of Mr. Conley and who is sitting to my left.
I was gonna say, why is he sitting? Okay. Mr. Conley Embry, I have a felony complaint that I need to arraign you on. I have a complaint here that alleges that on or about February 17th, 2026, at or near the area of 115 Dickey Court, Lansing, Michigan, that you engaged in the action in count 1 of witness bribing, intimidating, or interfering. that you did willfully impede, interfere with, prevent, or obstruct, or attempt to willfully impede, interfere with, prevent, or obstruct the ability of a witness to attend, testify, or provide information in or for the present or future official proceeding. And this was in violation of Michigan Compiled Law 750.1127A. That's a felony. Maximum penalty is 4 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for the commission of any other crime, including any other violation of law arising out of the same transaction. You understand the charge of the maximum penalty? You have the right to an attorney, and Ms. Straub is here because she represents you on another matter, which I'll call shortly. But you have the right to have an attorney represent you at all of your future court dates, and the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. You understand that? Okay. I just wanted to see if they were connected in there. Is he requesting the public defender?
Yes, ma'am.
Into a not guilty plea on your behalf, you are being charged with a felony, so you have the right to have a preliminary examination within 21 days of today's date. That's the date that you're being arraigned on the felony. Unless you waive the timeline or the court finds the cause to go beyond the 21 days. At the time of your exam, you have the right to require that the prosecution establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the individual who committed the felony. Do you understand your rights? You have the right to plead guilty, plead not guilty, or stand mute. If this matter goes beyond a preliminary examination and or if you stand mute, this matter will continue all the way to a jury trial. You're presumed innocent until proven guilty. You can maintain your innocence and require the prosecution prove your guilt by proving each element beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you. The right to subpoena witnesses to testify on your behalf, and the right to remain silent and not have silence be used against you. Can you get me this criminal history as well, please? You understand those rights?
No.
Okay. So these are, yes. Yes, okay. You're currently scheduled for probable cause conference before Judge Flores. He's right across the hall, June 4th, 9 a.m. You have a preliminary examination before Flores on June 11th at 9 a.m. I'm assuming he drew it because I don't have time. So
Right.
it's probably going to be transferred. It was given to Flores because my time is blocked because it's supposed to come to me because I have the companion file. So it's likely it might get changed, just so you're aware. If that gets changed, I'll have to find good cause to go beyond the 21 days to have it addressed, okay? Okay, we'll address this bond on that in just a moment. Now I'm calling people of the state of Michigan versus Cameron Conley Embry 26-00499 SM and people of the state of Michigan versus Chelsea Glover 26-00500. Appearances.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Conley Embry. We have a bit of a conflict situation with Ms. Glover. Yes, and so Mr. Etheridge did identify that late last week. I don't believe conflict counsel has yet been assigned.
I asked about the last court date. I said,
I asked about it a month ago.
how in the world are you all representing both of them?
It was a great point. We did bring it up with the office.
Okay, sounds good. And then, so Ms. Glover needs to get a new attorney.
That's right.
Okay. Chelsea Glover.
Yes.
You related to an Emma Glover? Oh, I used to go to church with her. How are you related to her?
That's my grandmother.
Hmm.
I'm sorry.
Every time I would be at church, she would ask me to write my number down. Every
Yeah,
single time she saw me.
she had a notepad. with her. She knows it.
Sweet home. Okay, let's see here. So we can't continue today on either of these matters, correct?
I would say we probably would need to adjourn to get counsel for the
Okay. So you're in the process of getting conflict counsel. I'm gonna go ahead and find good cause on the felony to go beyond the 21 days, have this reset, have it reset, have it set on my docket.
Yes.
You can speak.
If she's not here, do I have to keep getting it adjourned? Just to wait.
The complaining witness, you do, because there's a allegation now of witness tampering, which is,
But that's not with me.
I recognize that.
Oh,
I recognize that, but it's a co-defendant case. We don't need allegations of witness tampering for both people. Just that someone likely tampered with her and that's why she's not here. So because of that, I will not entertain a motion to dismiss. Let's see here. He's being held on this or case only? Or something
My
else?
understanding that he has been sentenced through 30th Circuit Court to 1 year in ICJ.
Our bond in the felony is 5,000, 10%. No contact with the alleged victim from the underlying matter. Is it Yamilet Heine? And no, all your other bond conditions from your previous file will apply to this. Doesn't sound like he'll be getting out in the. Okay. His new probable cause conference is June 25th before me at 9 a.m. And his preliminary examination is July 2nd at 9 a.m. Okay, let's reset this matter until. It's actually gonna use the. Oh, set up, yeah. I think I'm gonna have to resolve the tampering before I can proceed. Okay, we're gonna reset all of these for a little bit misdemeanors for June 25th at 9 a.m.
Runner.
I'm sorry.
I'm gonna sub in for Mr. Glover. I've been working with this family for a long time, but the 25th is not good for me. So we go.
What about June 2nd? I mean, to July 2nd.
Yeah, that'd be great.
Okay, we'll do July 2nd. You're going to sub in on behalf of Ms. Glover?
Yes, Your Honor.
Okay. We set those to July 2nd at 9 a.m. and then Mr. White has an opportunity to get discovery and get caught up at 9 a.m. That's also the date of the exam on the felony at this point. Any additional matters?
Nothing from the people, Your Honor.
Did you say the exam was the final?
Yeah, for his exam. She doesn't have an exam. Any additional matters?
Nothing from the people.
Nothing, Your Honor.
Okay, thank you. You're all set for today. This is the state of Michigan versus Daryl White, 5-02799. Yes, please.
Thank you, Your Honor. May the court assist prosecuting attorney Dan Smith here on behalf of the people.
Jamie White here on behalf of Mr. White.
Okay, this was final pretrial for domestic violence. And a bond violation. How are we proceeding?
Your Honor, at this time, you've moved to dismiss. We have attempted to reach out to the complaining witness in this case, and unable to reach her. People cannot move forward in this case without her cooperation, so this time we need to dismiss.
Objection.
Motion to dismiss is granted. We'll withdraw the bond violation, which I think is,
I think that's historically, Your Honor. I could be wrong unless something has developed since our last hearing, but there was a bond violation almost the time we arraigned that we talked about a couple of times. We've actually tethered for it. We removed the tether the last time we were here. Again, unless there's been some other development.
I don't think there's been anything additional. I just kind of withdraw it at this point.
Thank you, Judge.
I think it was allegations that he was with the alleged person, which I understand is that they both work together too.
Right.
Any additional matters, we'll get you a copy of this.
Nothing from the people, Your Honor.
Nothing, Your Honor.
You're all set. This is the state of Michigan versus Alexis Yurden, 25-03476.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
This is the, cover your appearance, please.
Yes, morning, Your Honor, Dan Doe, appearing on behalf of the defendant.
This was a final pre-trial. Is there a reason why your witness is on Zoom?
She was unable to get off work today. She received the subpoena late and her only way to appear was via Zoom.
Is she gonna be able to get off work for a trial?
Yes, she's indicated that she would. But my hope is that we can resolve this matter before trial.
She's at work right now.
Doesn't look like she's at work.
Ms. Ringel, you unmute your device, please.
Unless she works from home.
Good morning.
Why were you not in person today?
Because I just started a new job and I found out about the court on Saturday. So I knew I wouldn't be able to get off work. So they let me come in late today.
You say your job let you come in late today?
Yeah, I texted them yesterday and they said it was fine if I came in late.
So then why weren't you here in person?
Because I was told the Zoom information.
Who told you the Zoom information?
Dan Smith. Because I didn't know if I'd be able to get off work and then he told me yesterday I could come in late. So I just figured Zoom would still be fine.
No, you must appear in person. That's what your subpoena should have said. And Zoom is really only allowed if I approved it, not the prosecutor. Are you gonna be able to get off to come in for a trial?
Yes.
The trial is scheduled for July 7th.
Okay. That's plenty of time.
Do we have a priority case on that thing? This might. Jeez, hold me a second. What's the first name on Amy Stanfield? Amy Stanfield? Carter. Okay. Someone needs to, we'll have the prosecutor check on the one part. She's second in line for that date for trial. We'll have the prosecutor check to see if there's gonna be a trial in fact at that date. Is there a way to resolve this at all?
Yes, Your Honor, in fact, we were requesting second final pre-trial to confirm a possible resolution.
Okay, so you're not ready to go to trial. You think that you need another final pre-trial?
Yes, Your Honor.
Okay. So this is what I'll do. I'll convert July 7th to second final pre-trial. All parties can appear via Zoom for the second final pre-trial.
Say.
Any additional matters for today's record?
Nothing from the people.
No, Your Honor, thank you.
I didn't see the witness to be losing. Okay, Mr. Riggle, do you have any questions?
No.
Okay, you're all set today. Is Jessica Hahn here?
I'm not sure if she's online.
I don't see her. Matt? Gary. Let's see here. Is that the jury trial? No, something else, I'm sure. No Jessica Hahn?
A little bit more. So.
State of Michigan versus Brooke Streeter, 26-00488 and 00499. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Brooke Streeter is representing himself, correct? Excuse me?
She declined. Public defender.
Yeah, I think this is her second. Okay.
Can you hear
She was supposed to.
Can you hear me?
us, ma'am?
Yeah, I can hear you.
You were supposed to go and have your animals vaccinated back in April. How are we proceeding at this time?
They're vaccinated. I have the paperwork here. Do I email it or?
You could email it.
Okay. Is there gonna be an email address on the paperwork that I got for the Zoom?
There is not. Did you want her to email it to you directly?
Yeah, you can email it to me.
If not, I have a pen right here. I can write it down.
Yeah, you can write down my email address.
You can give it to her when you're ready.
DSMITH2 @ingham.org.
You said Smith, the number 2 @ingham.org.
Smith2 @ingham.org.
D like dog, Smith.
Okay.
Okay, and then once he receives that, we'll recall your case, okay?
Can I send it right now?
Yes,
Yes.
please do.
Okay.
This is the State of Michigan versus Sierra Walker, 26-01013. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appear on behalf of the people.
Yeah, I know the devil was a lie.
And it's,
No, she might not be in the bathroom, but. I was gonna say.
Assistant Public Defender Joseph Hardy on behalf of Ms. Walker.
Jim is in my courtroom. Is this your client?
Yes, Your Honor.
Okay, you spoke to her?
Yes, I did.
Is the matter resolved?
Yes, I believe so. Yes.
Dismissing it?
He gave us proof that the dog is currently vaccinated and licensed, so the people move to this.
You're all set, Ms. Walker. Your case is dismissed.
Thank you.
Oh, right, we're not telling the clients how to do it before. State of Michigan versus Keith Wimberly, 26-00818, 26-00822. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Assistant Public Defender Justice Straub on behalf of Mr. Keith Wimberly, who is here remotely.
These were pre-trials that were scheduled for Mr. Wimberly for retail fraud. How are we proceeding?
Thank you, Your Honor. It appears at this time that I have been extended an offer for the defendant to plead guilty to retail fraud third. The people agreed to dismiss the retail fraud second under the condition that the defendant pay restitution to Meyer and Target of both cases. We'd have a preliminary agreement that the amount of restitution is in the amount of $764.93. I believe defense counsel has reason to dispute that, so we asked at the sentencing that there be a restitution hearing scheduled for that same day.
Isn't he housed at the inpatient facility now? Or?
That's correct, Your Honor.
And there's a dispute in the amount of restitution you're saying?
Yes, Your Honor. The complaint is not super straightforward in terms of which merchandise was recovered, which merchandise wasn't recovered. So I think it just takes a little bit more digging on our end to read through the facts.
What is the requested amount of restitution?
The people are requesting $764.93.
Target, Your Honor, I think Target was $349.
That's in the affidavit of probable cause.
And then for Meyer, it was $414.94.
Yeah, so the affidavit of probable cause says $114.98 for that. So we'll set that for
So,
it.
I mean, I guess we can amend it when we get done today. We will amend it down to $114 for that.
Did they get the items back or no?
I do believe that they did recover some of the items, Your Honor.
It's typical for them. But sometimes it's food items, so they can't do anything with it. So I don't know. So
These are clothing items.
these were all clothing items. Okay, so no food items.
Wait a
And
minute.
you believe some things were recovered, so you will not, your client will not accept the 114.98 either.
No, he will accept the 114, Your Honor. The dispute is with 414.94. I'm not sure where that amount came from. So when I look at the complaint. I
Might have
see
been a
114.
typo. I don't
Could
know.
be, very well. Could be.
Yeah, because in my affidavit of probable cause says 114.98. Oh, okay, so we'll do 350, whatever it was targeted, and then the 114, your client will stipulate to that for the purposes of sentencing.
Yes, Your Honor.
Mr. Wimberly, can you unmute your device, please? He did usually have someone helping him, but I don't see anybody letting him. Okay, can you hear us, sir?
Yes,
Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury?
yes,
Okay, you can put your hand down. The offer was for you to plead guilty to the retail fraud in 26-00822. That's a retail fraud third degree, and that the people will dismiss the other file. Do you understand that?
yes,
Okay, the offer also includes you paying restitution. Do you agree to that or understand that?
I agree.
Okay. Okay, and restitution would be $463.98. You understand that?
Yes, ma'am.
Okay, you have to give up your rights in order to plead guilty. So you have the rights in both files to be presumed innocent until the prosecution can prove your guilt. Do you understand that?
Yes,
You have the right to maintain your innocence, maintain silence and proceed to trial and require the prosecutor prove each element beyond a reasonable doubt of each file. They cannot use silence against you. You have the right to question any witness called to testify against you at trial and the right to have witnesses subpoenaed on your behalf to testify. Do you understand those rights?
yes, I understood.
And you're willing to give those rights up to plead guilty to the retail fraud third degree?
Yes,
Anyone threatening you to get you to do that?
no,
Any promises to get you to waive your right to plead guilty?
No,
And you're not on probation or parole at this time, correct?
no,
Okay, you understand that by pleading guilty, it could result in a conviction that you might need to report to a current or future employer.
yes,
It also could have impact on where you can travel or get immigration status. Do you understand that?
okay,
Okay. As to the retail fraud, third degree, how do you plead?
guilty,
Factual basis.
Mr. Wimberly, on January 2nd of 2026, were you located at the Meyer on 6200 South Pennsylvania Avenue?
yes,
And is that Meyer located in Lansing, Michigan and in Ingham County?
yes,
Okay, and at that location, was the Meyer open to the public that day, at that time?
yes,
And did you proceed to take items from that Meyer while it was open?
yes,
Do you think that satisfies?
Yes.
I'm gonna do it.
People are satisfied.
The court is also satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. File number ending 818 is going to be dismissed for the plea agreement. The sentencing is for him to continue his treatment. I think he's at Cedar Roots.
This is correct, John.
And that he will pay restitution in the amount of $463.98, 114.98 to the Meyer, the remaining balance to the target, and that there's a $75 crime victim rights fee that will be assessed, plus a $50 statement of costs, and I'll waive discretionary fines and costs. Do we know how long he's in treatment? Okay, so when do we expect to get payment? So I can set this on a payment plan.
As soon as his term there is completed.
But you don't know when. No, I don't understand. There's someone back there.
She said next month on the first round.
Payment in full on the first. How much on the first?
How much do you? $50 a month.
The first is this week. It's not. First is Monday. I'll note they'll pay $50 per month beginning June 1st until paid in full. The first of each month, there'll be a payment due. Any additional matters for the record?
Nothing from the people, Your Honor.
Not from defense, thank you, Your Honor.
All set. You're all set, sir.
thank you.
You're welcome. Did you get Ms. Streeter's email?
Yes, we're dismissing. She provided proof.
Okay, Ms. Streeter, your cases are dismissed. You're free to go.
Thank you.
You're welcome. We have Mr. Jerry Gary here, who's representing him. State of Michigan versus Jerry Gary. This is in 26-00278. Appearance, please. We don't need a prosecutor for a
Okay.
sentencing.
Perfect. Assistant Public Defender Jessica Straub on behalf of Mr. Gary.
Okay.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
This matter is scheduled for sentencing, and I do have a pre-sentence report. I'm assuming you got a copy of that, counsel.
I did, Your Honor.
Any reason to make updates, corrections, or deletions?
I do not believe so, Your Honor.
Nothing from the people.
Allocution, please.
Your Honor, it does appear based on the report as well as my interactions with Mr. Gary that he is forthcoming about this incident. He did express regret for having to resort to these means. He also was forthcoming about the fact that at the time he was homeless and hungry. We would ask the court to consider, based on the recommendation from probation, time served for this matter.
I'm just trying to, is this the one that the steaks were stolen?
Yes, Your Honor.
Where was he going to cook them?
I don't know. I do believe parks have grilling.
He was gonna grill these in the
I'm not
park.
sure. I'm not sure.
Possibly.
He might have been banding together with his friends.
He was homeless and hungry and he needed $174 worth of steaks to cook. Is that what he told you?
That is what he told probation.
Mr. Gary, you were gonna eat $174 worth of steaks.
I wasn't gonna eat 174, but I was gonna eat some of them. And, I was homeless, I had nowhere to go, I didn't have no, no financial capability of getting any food or anything like that. I don't have any state assistance or anything like that, I didn't have any credentials, no ID, I was just struggling and, deeply, I was in depression, I didn't know what else to do, so instead of me trying to seek some type of help, I seek the streets for help, and I got a problem, man. It's a problem. I got a problem with with retail frauds, and I got an addiction. So
You have an addiction with retail fraud or another addiction?
no, I got an addiction with with drugs, and that drugs kind of led up to that, and just being homeless and depression.
Okay, okay, and so you weren't gonna eat all the steaks, you were gonna, redistribute them in the streets? Is that what you were gonna do?
Yes, ma'am.
That's what he does. Oh, sounds good. And he, I believe, has a number of pending matters. Has he been able to get these detainers all addressed in current? He's not on a bench warrant for anything still, is he?
I do not believe so, Your Honor. I do see bench warrants on here
Mm-hmm.
from the 12th district in Jackson. I was not aware of this.
They were dismissed. That was dismissed.
When was it dismissed?
This was dismissed last week. I went to court last week, so they dismissed. They ran the time, the 4 months I've been here. They ran it concurrent, and they dismissed it. I don't know if it's in the data system yet, but I just went to court last Friday.
So not being.
Well, it wasn't dismissed. It was they ran the time concurrent, and
That's what I was waiting for.
Sorry.
Definitely wasn't dismissed. The
wasn't
case was not
dismissed.
dismissed, but you're no longer in bench warrant status though, correct?
Yes, ma'am.
Okay, sounds good. You think you've served 85 days on this file? It's my understanding. Yeah, because I think I amended the bond in February. Okay. Okay, so what we have here is restitution owed in the amount of $174.44 to the Meyer. $75 crime victim rights fee plus $50 state minimum cost will be assessed. And I don't know when he's getting out, so he'll have to make a payment plan because he has a pending felony.
That's
Correct.
correct.
Okay. Okay. So I don't know when you'll be out, but we'll set this up for you to report to get on a payment plan once you are out of custody, okay?
Yes, ma'am.
Any additional matters for the record?
None from the people, Your Honor.
Not from the bench, Your Honor.
You're all set, Mr. Gary. Best wishes to you.
Thank you.
You're welcome. State of Michigan versus Juan Kramer, 25-03198. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people. Assistant Public Defender Joseph Harding, Mr. Kramer, who is standing here.
Are you looking to walk through, Ms. Sutter?
Yes, thank you.
Okay, this was prepared for sentencing. I have a pre-sentence report from the 15th of May. Did you get a copy, counsel?
Yes, Your Honor. Yes.
You need to make corrections, updates, or deletion.
Nothing but a people. No, Your Honor. Thank you, Your Honor. At this time, we have no objections to the recommendation for 10 months of probation. We don't believe that there's going to be any issue with the no contact order. And it's our client's position that he doesn't intend to have any type of contact with Mr. Ritter whatsoever. He's currently employed at College Chunks full-time, so he is making wide use of his time. At this point, and also he has a 5-year-old son as well that he's currently taken care of. We believe he does not have any type of issues. We don't believe with any type of alcohol or drugs. As such, we believe that the testing will be unnecessary and not burden to him. Other than that, we have no objections to anything else within the recommendations.
You have your.
Yes, the victim is here and he would like to testify. State your name first.
Joshua Ritter.
Okay. How are you today, sir?
I am short and losing my hair.
Short and losing your hair?
That's
Well, I'm sorry. I'm sorry, that's outside of anything I have control
I
over.
figured you needed to laugh. It seemed like I dealt with some young people today.
Well, I appreciate that you have a sense of humor about this. That's good. What is it that you want the court to consider, sir?
Ma'am, I appreciate you letting me get to speak throughout this process. I've been attentive and attended every single one of these and never had a chance to have my voice heard. This issue started because I told Mr. Kramer that if he hit his child in the face again, I would call the police. And from that me telling him that, it turned into this big, huge altercation. I obviously have one eye. I'm a disabled man. Because of this altercation, I broke my foot and I tore the ligaments in my knee. I am still on crutches from this. Juan is my nephew. He is my older sister's oldest child. My older sister has passed away.
You all are related?
Yes, ma'am.
Got it.
And I'm speaking on behalf of the family here. He's gone down this destructive path for some time. His alcoholism, where he drinks nonstop and then begins to be belligerent and try to fight everyone around him. He has previous cases where he destroyed property, where he had his child removed, or being bad to them. His family is worried about him. We are worried that he's going down a destructive path, that he's going to hurt himself or get hurt by someone else. In this altercation, ma'am, I never threw a punch. I subdued my nephew. And when I told him that I would let him up if he calmed down, that's when he pushed me on my blind side and caused me to blow out my knee and break my foot. He has no remorse for this. He has told family members that he is only pleading guilty here today because he thinks he's going to get probation. The family wants him to get the full extent of your judgment so that he can hit rock bottom and hopefully be able to get past this destructive phase in his life, because we're worried that what's going to happen next is he's going to get hurt or he's going to hurt someone else. And that's what I would like to say today. Thank you for allowing me to speak.
Thank you for bringing your statement. And I apologize that you have to come here under these conditions. It's always troubling when we have to have a victim here, but it's especially troubling when there is a family dynamic there. Because family needs family. in a way that's supportive.
We are happy to support him again. My mother raised him. My mother is taking care of him and his family. The 5-year-old he claims to take care of, my mother took care of since he was a baby. We are happy to have him in our family again, but we need him to get past this behavior.
No, you just want him to get past the destructive behavior. Thank you. Okay, Mr. Hardy, did your client or do you want to make any statement?
I would just say that just based on the PSI and also speaking with my client, I believe that the question of whether he's suffers from alcoholism, we would contest. Would also contest the fact that he doesn't take care of his child. This is contention that he is, someone that's there for his son. So other than that, there's nothing further to say regarding the statement.
Can I say one thing, please? We're happy to take care of his son, right? If he goes to jail and has to do it, we're happy to take care of him. We've been taking care of him. He's the only home he's ever known is ours.
Mr. Kramer, want to say anything?
Yeah, that's a whole lie. I don't have a problem with alcohol. I don't drink. I don't drink at all. I don't drink at all. And if I do drink, it's on occasion, but I don't drink religiously. I don't get drunk.
You can't say.
No, I mean, I'm
Sir,
saying,
sir.
no, okay,
Sir.
I get what you're saying.
Look, you can't say I don't
No,
drink at all. I don't
no,
get
you're
drunk.
right. No,
Sir,
you're
and
right.
I don't
I mean,
drink at all. I don't
you're
drink at
right.
all. Why are you
You're right.
talking over me right now?
Oh, I'm sorry.
You can't say I don't drink at all. I don't drink at all. I don't drink at all. And if I do drink, you see what I'm saying?
No, I get what you're saying. But
So
no,
you do drink.
No, I'm saying I haven't drank in a very long time, but I have drank, before, but I don't drink anymore. And I do smoke weed, but that's not a problem. And I do take care of my son. I've always had full custody of my son since he's been born. And then, yes, I've had a problem with, his mom passed away. Yes, my mom was taking care of him and foster him until I got my stuff together and did all the, stuff to get him back. And I did that to get him back. And then they were helping me and I was working 2 jobs and they were watching him. And that's what they were doing. And then all of a sudden they got to where they wanted to control me and tell me what I couldn't do with my son and how I was always a bad person when, it's a 2-side story. But I don't drink. I don't get belligerent drunk. That's what I'm saying. I only smoke weed and that's it.
You have a medical marijuana card.
No, it's not. But I mean, if I have to stop smoking, I will. I'm not.
Well, you will have to stop.
Yeah,
smoking.
no, I get that. But like I said, I'm not, what I mean? I don't drink. So everything he's saying is.
Okay, so I'm reviewing his prior criminal history. I only see one other conviction. It was for the malicious destruction of personal property. That could be what your uncle is alluding to.
I did probation for that too. And. Okay, yep, okay.
You have custody of your child?
Yeah, full custody. I'm in Homeless Angels. I'm trying to get housing. I'm trying to do better. I got a job. I'm trying to do
What do you mean you're in Homeless Angels?
I'm at Homeless Angels.
Is that where you reside?
Yeah, that's where I live at.
And your child lives with you?
Yeah, he lives with me, and we're getting housing. I'm doing all the steps I need to get, back to where I need to be, because like after his mom passed away, I fell down. And then they, I thought my family could help me, but it turned out they were not the people I should have went to. I figured it out shortly. My brothers, my family, they told me not to, and I did anyway, thinking I could give them the benefit of the doubt. I should have done that. I did that after his mom passed away, thinking I had a family, and I didn't. I should have, went down with Angels in the beginning, or found a way to do it without them, because this is where I'm in the situation now because of them. And it's not, they say it's just me, but it wasn't just me. It's a thing of every time I came home, I was a problem. Every time I came home.
How were you in this situation because of them?
No, because I'm saying like every time I came home, it was a problem. I was a problem. Anytime I said something to my son, it was, oh, you can't do that with your son. The day this happened, all I did was come upstairs to go beeline to the bathroom and help my son get ready for school. And he stopped me, or no, you don't need to go down to help your son. You need to go downstairs. You come downstairs, I'm gonna call a cop. What do you mean? That's my son upstairs. So who you tell me I can't go to help my son in the bathtub? He's like, oh no, he don't need your help. He knows how to do it. And then I told him, okay, well, I'm taking him down to the bus. No, mom's gonna do that. What do you mean? That's my son. How can you tell me what I can do when I send my son? And if I'm coming up just to take care of my son, why are you telling me anything? Why are you trying to start a problem?
And you have full legal custody.
Yeah, I have full legal custody.
They don't
I
have
paper. They have no custody. I have full legal custody. That's what I'm saying. It started from, it just start because that day, it started from constant, oh, you're the problem, and them trying to interfere with me and my son.
Okay, and is it true that you told probation or provide information to probation that you believe this was actually self-defense?
No, I didn't.
You didn't tell them that this was self-defense?
No, I didn't say none of that.
Okay, well, is this your handwriting?
Huh? Oh, I mean.
Is this your handwriting?
Oh, yeah, but
okay, it says assault and battery was assault and battery is self-defense, and I wanted to get this over with and move on with my life.
Well, yeah, just because
How was it self-defense?
Well, because like I said, he's trying to say that he didn't do nothing, but he came at me and pushed me first, so I pushed him back.
Okay.
You know what I mean? But that's what I'm saying. I'm trying to like get away from the family. I'm trying to, take care of my son. I'm trying to move on with my life and go,
If he pushed you first, why would you take a plea?
Because I'm just, like I said, I'm just trying to move on. Like I'm trying to.
Well, you can't.
I know. I understand what you're saying.
You took an oath that you were
I understand what you're saying.
Yeah, no, you don't understand because you're talking over me.
Oh,
you took an oath that you were supposed to tell the truth and the whole truth. Whole truth, not part of the truth, not your variation of the truth so you can get it over with, but the whole truth under the penalty of perjury. Do you know what perjury is?
I mean, yeah, that's what I'm saying. Like,
you can take your hands out of your pocket. Perjury is a guilty act for lying under oath.
Yeah,
and so you took an oath that you would not lie under oath, or otherwise you'd take your hands out of the pocket. Otherwise you could be subject to a penalty, and that you would tell me the truth and the whole truth. But now you're saying that in fact your belief or the position was that you were pushed first.
I mean,
is that true?
I mean, like I said, like I said,
were you pushed first?
Yeah, but I mean, like I said.
So then why didn't we not move forward with a self-defense?
Because I thought if I can just do this and just get away, move on my life and take care of my son, that I could just be there for my son and then not worry about nothing else and work my job and try to get a house and get through this homeless thing. Because I've been homeless I was homeless. I went to hotels. I was paying $2,000 a month, and until I got to this homeless angel place. So I was just trying to just get my life, back together with my son.
How in the world?
So I mean, I understand what you're saying.
How in the world is a guilty conviction of criminal conviction going to help you move on with your son's life? How does that work?
I don't know. I don't know.
You could have went to trial and had and gambled. Did you plead guilty to the charge?
I didn't want to gamble.
You pled guilty to the charge.
Yeah, no, but that's
you didn't get a plea deal.
No, you're right. I just didn't want to. I think
there's a cognitive issue.
No, I understand, but I didn't want to like.
There's a cognitive issue. Did you know that there was a cognitive issue?
Yes, ma'am.
I'm not talking to you.
Oh, sorry. I thought you were looking at him. And in conversations with him, I did not sense any cognitive issue in discussing.
How many times did you have conversation with him?
Multiple conversations. And
you didn't know that there was a cognitive issue?
Well, in our conversations, I believe that it was very clear that that the only way there was going to be any type of guilty plea was that if he believed that he was guilty in this scenario. Believe that was said so on the record as well.
That's not what I'm asking you. I didn't ask you any of that, because you have opportunity to counsel him, and it shouldn't just be about whether or not we can get a guilty plea.
No, of course.
You're supposed to counsel and figure out what the underlying issue is and figure out what he tells you. If I'm assuming if he told me and he put it in writing that this was self-defense, and he also told you that. You did not, one minute with him, you should have been able to determine that there was a cognitive issue here. No?
Your Honor, when speaking with him, I believe that I didn't see any contradictions.
Are you
He was
okay?
Clearly.
Yeah, I'm okay.
Okay, why do you keep having a heavy?
No, I just thinking like, I'm just hoping I didn't mess anything up.
You did not mess anything up.
I'm just, like I said.
Yeah, but yeah, you need to calm down though.
No, you're right. I just, you're right.
There was none of the excitability or anything in any of our conversations. I believe that he understood exactly what he was being charged with.
I'm not asking you if there was a issue that required forensic. I did not ask you, was he incompetent?
Oh, okay, I guess.
That's not what I'm talking about.
Okay.
Cognizant, because it's cognitive issues and being incompetent are not the same. Because I can order him to go and get some treatment for an issue right now, just based off my communication with him, that he probably needs to be treated or assessed for something cognitively. Mr. Kramer, I'm going to tell you this. You never plead guilty to something that you don't believe you're guilty of just to get it over with. Do you understand that?
I understand.
That's inappropriate.
I understand what you're saying. Like I said, I've been going through a lot. So
I can imagine.
I've been homeless. I've been just doing what I can with my son. So it just been.
I can imagine.
Like it could be just. I could just.
Have you ever been diagnosed with anything cognitively? No.
No, I went to therapy when his mom passed away, but that's.
Okay.
Yeah, I did therapy when his mom passed away, but they didn't say anything like I was like having problems or the anger problems or nothing. It just, obviously like if somebody does something to you and you feel threatened and scared. So, but like it's not even the point. I understand what you're saying.
Okay.
But like I just thought like he doing this would just help my son.
I get it.
So I just
okay.
I wasn't trying to lie or I was just trying to move on with my son because it's just been so hard. And I've been homeless for, since, beginning of the year, and I paid $3,000 in hotels until I got the homeless angels. And then finally I kind of got a break. And then I was like, shit, like maybe I should, sorry for the language, I want to be there for my son. I want to do for my son. I want to move on from this family. You know what I mean? Because like I said, they're trying to tell me I'm toxic and I'm this, but no, it takes two sides. It doesn't just take one person to do something or act a certain way. There's always two sides to the story. And he's gonna say what he's gonna say, but that's not the truth. But I mean,
I believe that there's two sides to every story, but if you waive your right to tell your story, how do we know the other side?
I do. I understand what you're saying. I shouldn't have done it that way. I should, but I just was thinking of my son. And that's what I thought as a father I should do, especially as being a single father. And he's all I have. He's all I have. His family, no, they're just playing. You know what I mean? He's saying what he's saying now, but that's not what you're saying to me when I live with him.
Okay.
You know what I mean?
I get it, sir. Are you working full time?
Yeah, I'm working full time. I'm trying to get daycare so I can work more full time. Then I work 35 hours a week, and I get him out of school every day. He goes to school every day. I make sure he goes to school. He's doing better in school. Even teacher told me he's doing better in school ever since I took away from him. You know what I mean? I had a conference. You know what I mean? It's always been a whole lot since, But no, he goes to school. I make sure he goes to school every day. He eats. We're in Homeless Angels. I make sure he showers, brushes teeth. I make sure he does what I go to work every day. I do what I have to do, just like I said, to get to where I need to be in life, to where I don't need no one else but me and my son.
Oh. I'm going to modify the recommendation. It's going to be 9 months of probation. While on probation, you have the following conditions, okay?
Okay.
I am going to order that he participate in cognitive behavioral therapy and anger management.
Okay.
You need to maintain your employment.
Yep.
And provide evidence that you are employed to probation, okay?
Okay.
and not to use, purchase, or possess alcohol, drugs, or marijuana
Mhm.
unless you have a valid prescription, okay?
Okay.
We're gonna continue the no contact order with or between you and Mr. Ritter,
Of
okay?
course, I don't want nothing to do with it. That's why.
You're not to engage in any assaultive or threatening behavior.
Yeah.
Do you understand that?
Yeah, can I speak on say something else too?
Yeah, sure.
And then like just to, like even when I got kicked out, like when I got to PPO, my mom tried to keep my son from me for 3 weeks until I had to go to guardianship court just to prove that I had full custody. But why don't you just give me my son when I went to get my stuff? I had the cop escort me to go get my stuff, and my son, she refused to give me my son. Him too. They both refused to give me my son. And then when I have full custody, you can't refuse that. And I had to go say I had to wait 3 weeks just to get my son back. Till November, it went from the time to from October till November 17th, and I finally got my son back. And I was like, they're like, oh, you're gonna go get my son from school, from the house? No, I'm gonna go get him from school because I don't want to deal with that problem. You know what I mean? And then right after the court date, my mom was screaming at the CPS lady, yelling at the CPS lady. You know what I mean? Yeah. So it's like I was in the court, and right when she left, she started screaming at CPS like, "Oh, he's gonna take him. Of course I'm gonna take him. He's my son."
I understand.
You know what I mean? I had to wait 3 weeks just to get my son back. So you know what I mean? I've been going through problems with him for months.
Right, but it sounds like it's whatever the underlying issue is centered around the relationship that they may have had with your son.
Yeah,
It sounds
but
like
right,
at
but
some point that they were did they
They
raise
just
him
watched
at some
him, but
point?
they didn't take care of him because every time he would have a problem, it would be that they wouldn't do nothing. And then even the school told me, oh, he would come.
Okay.
And I would tell the teacher would say, oh, I'll email your mom, and she would get on me about it and tell me I wasn't doing something right, or not email me back, or call me and yell at me.
Let me. I understand your frustrations.
Yeah.
Are you still in counseling, sir?
No, I'm not, but I can be.
You should be.
Yeah, no, I like that. I can do that.
You should be in counseling because you have a lot of anger.
I mean, I've been going.
Sir, you have to listen to me now.
Yep.
You have a lot of pent up emotion about a lot of things, and
Yeah.
you need to be able to flush those out appropriately.
Yeah.
So I am going to order that you re-engage in counseling. Were you getting that through CMH at all?
No, but I was getting it through. I was doing the family, like it was like family something there by the say on Jolly and Dunkel by the McDonald's over there.
Okay.
Yeah, that family place. I was doing it through there, but then like I said, I been going through this church group even when I've been in open. So I've been, talking about my stuff and doing, what I need to do in that and talking to people and so I've been
You
taking
need to
steps to
be,
that.
right, I get it, but you need to get
Yeah,
back in
I understand what
counseling,
you're saying,
okay?
and I will.
Okay,
I
and I'm
mean,
ordering that at this
Yeah.
point. Because I think you need it. It sounds like there's been a lot of moving parts and there's some, I think, underlying cognitive issues that also probably need to be addressed.
Mhm.
Ultimately, though, you have a son that it looks like he's your motivation.
Yeah.
And so you consider that as you're going through this program, that you're trying to get yourself in the best possible position for you to be the best father. And that means you have to be an example. Okay, you have to show him self-control. You have to show him how you are calculated as to when you speak and when you don't. You're calculated as to when you react and when you don't.
Right.
And not to say that you don't protect yourself, but if you are going to protect yourself because you have a lawful reason to do so, that you don't throw away your rights outside of that. You're protecting yourself in all areas because some of the decisions I think that you've made in the last couple months were maybe not in your overall best interest, but I understand that you wanted to get what you thought was a resolve so that you can move forward because you've been through a lot.
Yeah.
You're going to do the cognitive behavioral therapy, you're going to do the anger management, and you're going to get back in your counseling and provide evidence of that. You're going to maintain your employment, and again, no alcohol or marijuana or a controlled substance. You did report daily use, at least to our probation officer, of alcohol.
Oh, I am.
Okay, so I am going to order that you submit to random preliminary breath testing and urinalysis testing. You have to pay the fee for that, okay? I'm only going to order that at this point for 60 days for the next 2 months. If there's no issue, I'll suspend that because I recognize you have limited resources, okay?
Yeah.
There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also will be assessed. This probation is $30 per month. So your total probation fees is $270. I'll waive discretionary fines and costs, and you'll be able to make monthly payments on this, okay? So that's $395 total. It's about $43 a month for probation oversight fees. You'll go downstairs, you'll check in with our probation department before you leave here today, okay? Do you have any questions regarding your probation?
No.
The additional matters for the record.
Nothing wrong with you. Not for the defense, Your Honor.
You're all set, thank you. You're all set, sir. You're gonna go down to probation. He has the file. He is also a probation officer, so you can wait for him. This is the state of Michigan versus David Portis, the third. This is 25-03527, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appear on behalf of the
Assistant Public Defender Justice Rob, on behalf of Mr. Portis, who is sitting to my right.
Okay, this was scheduled for sentencing today. I do have a pre-sentence report that was prepared the 18th of May. Did you both get a copy?
Yes, Your Honor.
Yes, Your Honor.
We need to make corrections, updates, or deletions.
From the people, Your Honor.
We do have a couple of updates, Your Honor. Number one, he was reflected in the report to be working for Ventura, I believe. He has since parted ways with Ventura and now is working for MSG, and he'll be starting there tomorrow.
MSG, what is he doing there?
It's a temp agency. I'll be melting metal.
Is the earning the same or more?
No, it's a lower earning.
Lower earning? I was gonna ask you how you were living off of $700 a month in the first place.
So I have help.
Okay, well, you'll provide an update to probation. Any other changes?
Your Honor, there was also mentioned in the report that Mr. Portis is not eligible for 769.4A based on some assaultive convictions. I was not able to pull any of those assaultive convictions in my iChat, neither were they listed in the convictions section of this report.
It probably was a typo because I have this. Oh, wait a minute. From Chicago?
Yes, ma'am.
That's why. He's got assaultive actions from other states.
And their convictions, Your Honor?
Yeah.
May I ask what the conviction was for? Because the only thing I've ever done time for was drugs.
I have an aggravated battery from 2007, Cook County.
An aggravated battery?
Correct. Let's see. Looks like he did probation for that.
I've never had probation for an aggravated battery.
He is a third, Your Honor. Is it for our
I
third?
said the third, let's double check. And
Yeah,
make
the
sure they
only
pull
thing
the
I've
third.
had
Give me
probation
just a
for
moment,
was
sir. They would have ran. That, this could be a problem right here. It says right here, name, David Prince Portis Jr. the third. Can't be Junior and the third. Sir,
so that's
sir, why are we talking right now? Didn't your attorney tell you to calm down and take your hands out? Nobody asking self-control.
I know, I'm fine.
Yeah, but if your attorney tells you to stop talking and if I'm talking, You can't talk over me. Even if you have something you want to tell me, you're not allowed to talk over me. And then I have someone's recording. She can't record both of us talking at the same time, okay? Okay, let me see. That was the Michigan criminal history. I'm trying to see what they ran here. It doesn't tell me what he ran, but the 2007 he would have been 16. So I don't know how that could be him.
Can I speak?
You can.
So I was gonna say, in 2007, I was still in high school, right? There's no way I was county bound. You're not county bound until you're 17.
But didn't I just say that?
I'm just saying. So
I'm smarter than you think.
For them to have that like that.
You think did I figure that out without you telling me?
Maybe.
Maybe?
I'm not in your head, so
Did I just say it on the record? Didn't I just say that he was 16?
Yes.
Did it? So I figured it out without him telling me.
Yes.
I was just explaining.
Yeah, my thing is you're not in control of yourself right now. So I don't know what they pulled, but this criminal history, which is extensive, from the Cook County, Illinois, I'm inclined to believe is not his, just based on the dates of the convictions. Any other things you want to address, counsel?
Yes, Your Honor. I do believe in the second paragraph of that report, it also states that this officer cannot rather than this officer can. I do think that was a typo. I could be misreading this book.
Let's see who the officer was. Oh, no. Oh, it's Nathaniel. Perfect. I have questions. What did we pull for this, his criminal history? Because this, I don't think this is his. Yeah, I don't think this is his criminal history for this state of Illinois, at least. Okay, you can have a seat. Mr. Neff is going to rerun the criminal history. Okay, let's see here. Let's see, State of Michigan versus Dominic Trevino, 25-03820. He's very stupid. Yes, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Jessica Straub, on behalf of Mr. Trevino, who's standing to my right.
How are you, Mr. Trevino?
Doing good.
I have a pre-sentence report that was prepared on the 21st. Did you get a copy?
Yes.
Yes, Your Honor.
You need to make corrections, updates, or deletions.
Nothing from the people.
Not defense, Your Honor.
Allocution.
Mr. Trevino was forthcoming throughout this entire process about what happened that evening. He did make mention during one attempted plea hearing that he thought his case could be self-defense. He has since recognized that the law actually doesn't support that and has been very accepting of that fact. He takes full accountability for his actions. In fact, since his plea hearing, he has completed a number of courses, including understanding emotional mastery, anger management, conflict resolution, as well as fundamentals of domestic violence and abuse. I took this initiative upon himself to do these things to demonstrate to the court that he does take full accountability for himself.
and to show his remorse for what has happened. We would ask this court to consider that in your sentencing today, Your Honor.
Do we have another matter pending? That's what I thought, that I dismissed.
Yes, you dismissed. There was some issues with the.
I remember. I remember another one. Whose plea failed. Original. Did your client want to make a record?
Yes. I just wanted to start off by saying how sorry I am for that night. It took me a while to like go past my pride to realize that, you know, I could do something like that. I was raised differently, brought up differently. I'm a family man. I'm completely embarrassed from that night, and been making steps to learn how to deal with certain situations like that. And you know, I just want to continue to grow as a person and be able to continue to take care of my family and going to church, taking my daughter there, and just trying to make the right steps to not make that same mistake again.
In my understanding, you have a child in common with the protected party?
Yes.
Okay, is there a family court order?
Not yet.
It's one pending?
No, Your Honor, but I believe there is something going on with the Child Protective Services thing, so
I don't know what you mean.
I'm not.
There's a
exactly
CPS
sure.
case?
I'm not sure, Your Honor. I'm not sure if the matter that was dismissed is supposed to have happened in the presence of the child, then CPS would be involved.
Oh, okay. But he's not been contacted by CPS?
I honestly just got a call from him while I was sitting here, so that's the only reason why I know.
The concern that I have, and this is why I asked, is the no contact order as it relates in this file. Based off of the allegations in this file, the allegations in the bond violation, which I used my discretion to dismiss, not because it wasn't enough evidence to sustain a violation. We could have an officer to tell us whether or not you were where you had no business being. But, and then also the other concerns that led to the prosecution's motion to dismiss the felony, I believe it was. Those should cause you great concern about how you're interacting with the mother of your child and that you need a court order. Those should cause you great concern. They cause me enough concern that I'm not going to lift the no contact order unless there is a court order. Really just for your protection, because it could cause another case otherwise. And we don't have time for that. Hope you don't have time for it. And so you're gonna need to get something, even if it's a temporary order. The only thing I will allow at this time is a third party to make communication for the purposes of childcare. But I'm not going to lift the no contact order. You understand that?
Yes, I do. So in order to do that, I would that be friend of the court?
To get a child,
Get
yes,
that
we need to
process
file something at the front of the court, correct? To get some kind of order in place so that you have an arrangement signed by family court judge that enforces your parenting time. My understanding, though, is that your mother is going to be the third party.
Yes, Your Honor.
And so I'll continue with that at this time, for the purposes of this. Any other allocution?
No, Your Honor, would you like the proofs of the courses?
Yes, please.
Oh, yes, Your Honor, we would like to.
Thank you. Okay. All right, let's see here. So you did complete anger management. Very good. And you were saying something else?
Yes, Your Honor, we would like to bring up the issue of tether. I do believe that.
Did I add tether?
Yeah, Mr. Trevino does.
Oh, it looks like I added it on the 27th. Well, I didn't add it. The magistrate added it on the 27th. But I think that was when she maybe, yeah, when he was arraigned for the bond violation. So that could have been addressed at the last court date and removed. So he can have that removed.
Thank you.
The tether can be removed and we'll notify them. And then in order for you to get a term of 769.4A, you would need to do probation. You understand that?
Yes, Your Honor.
So the court is going to grant 769.4A. 6 months probation is the sentence. While on probation, you have to maintain your employment and provide evidence.
Yes, Your Honor.
Of that, you've already done the anger management. You continue no contact order with the victim. And you will continue to not engage in any assaultive or threatening behavior. You're not to use drugs or alcohol without a valid prescription. I'm not going to order any testing at this time. You have to be at any bars or nightclubs. Do you have any questions at this time?
Oh, yeah.
Are these our copies?
Yes.
Okay. I grant 769.48 already. I did. Okay, there's a $30 per month oversight fee that you're responsible for. 6 months probation, and I reduced it from the recommendation A because you've done the a large of the programming that we would have ordered you to do, but also because you don't have the right to early discharge when you are on probation for an assaultive action. So we'll do 6 months at this time. So that's 180. I'm sorry. $305 total, because you got $75 crime victim rights fee plus $50 state minimum cost and the $30 per month oversight fee, okay? And you can make monthly payments on that, okay? Do you have any questions at this time?
Is that all the payments we set up through the online portal or through it?
Well, I know you can pay at the criminal traffic counter, but you also have the ability to pay online monthly as well, okay? You'll check in with our probation department before you leave here. Any additional matters for the record?
Nothing from the brief, Your Honor.
Not from defense, thank you.
Thank you. Back on the record in the matter of David Porter III. Excuse me?
Portis.
Did you hear me call your name? You can come on up here. Okay, Mr. Portis the third. We had his criminal history reran. These convictions go back to his social security number. So it's not for the court to flesh out for him. That's for him to flesh out. Whether someone used his criminal history or not, he has assaultive convictions on there. So I cannot grant him special status because of that. The only thing I can do at this point is if you would like an opportunity to try to have that flushed out, I can reset this to give you an opportunity to do that.
Yeah, if that helps.
Yeah, you would have to figure out how you got these convictions on your record from in Chicago.
I can say that at one point, somebody was using my name. They actually locked up the person that was using my name, and it was a family member. So maybe that's why it's popping up like that.
Yeah, I can't operate off maybes. It has to be actually flushed out and removed off your criminal history if that's the case. And you can talk to your attorney in private for more direction. Obviously, she can't represent you in the state of Illinois, but she can give you some guidance. I can reset this to allow you that opportunity because otherwise I can't give you the special status.
Would the court be amenable to lifting the no out-of-state travel for him to be able to handle these matters in person?
I don't know why I thought he had already gotten that with this.
We definitely brought it up, Your Honor. I'm not sure that.
Oh, he had a child support warrant. Is that what it was?
Yeah.
There?
Everything's in Chicago.
You have child support warrant in Chicago? Okay, so he's got to go turn himself in on child support warrant anyway. No?
No, they just took my license from me. That's what's been holding me away from getting a job. I have to go out there to set up court dates to determine what my child support is going to be bars from them taking my license.
If they run their child support anything like the state of Michigan, you're going to be taken into custody and a bond will need to be posted for the child support per statute. So what is it that you're requesting?
And he be allowed to travel on state.
So he's gonna go to Chicago so that he can try to get this matter resolved. Likely get arrested on the warrant. Then he's gotta figure out how he can post his bond. And then we resolve this after he can get that fleshed out. That might take him some time. I don't know what the timing is. I'm gonna set this out for 30 days. I'll give him an opportunity to return to Chicago for that purpose. He's got to maintain communication with you regardless. If you even get taken in custody, you got to let her know, hey, they got me in custody on this child support. Okay, and then if that's the case, arrangements can be made to have him appear virtually from Chicago if that needs to happen. But we have to have his communication with you for that purpose. Give me another.
June 30th.
June 30th at 9. Okay, supporters, you definitely have to stay in communication with your attorney. Even if they take you into custody on the child support, you definitely want to get that cleared up as quickly as you can. You understand that's more priority than this case, that's for sure. Okay?
Yes, ma'am.
Okay, and then during that time, and I would imagine you would be eligible for a court-appointed attorney there, if that's what you're looking to do. You would want to get your attorney's attention to the fact that there are some convictions on your record that you're disputing are yours, so that you can get those off your record, okay?
Okay, what if I can't get everything lifted within your time frame? How does that work?
No, I'm just giving you 30 days so you can give us an update, not so that you have, I know it's gonna take you more than 30 days to get that lifted. I can promise you that. That is just so you can maintain communication with her and give her a status update, okay?
Okay.
Any additional matters?
Nothing from the people, Your Honor.
Not from defense. Thank you, Your Honor.
You're all set. What's your name in the jail?
William Files.
What judge are you looking for?
Florence.
You said who?
Judge Florence.
Judge Ward? Judge Flores?
Florence.
Well, I'm neither of those, so let's Can you get the deputy in there, please?
Yes, ma'am.
It's quiet on one floor. Is he? I think there's people over there using. It's just really quiet.
I'm jinxing, George. It's a good thing.
I know.
Oh, the trees. Yeah, I just should have really. Oh,
Yeah.
Of course. Yeah. I mean. He's looking for Judge Flores, he says.
Yeah,
This is not Judge Flores' courtroom.
okay, thanks. Exactly. Oh.
Yeah, I think it's 480. Just a second.
Okay, let's see. Daryl Anderson still here? He was here. He might have lost him. Daryl Anderson? Okay. Let's see. Tony Austin is no longer with us.
Yeah, I don't know if they know.
Yeah.
So they, I don't know.
There's a show file, so I just pulled the file. Raylene Higgins here.
We just got an email from Cody. He paid in full over the weekend.
Wonderful. Let's see, Ricky Houston here. No Ricky Houston. Jemiah Myers. She's not here. She's on there. That's what I thought. She's in Rise right now. Ms. Myers, can you hear me? She's not unmuting. Can you? Can you unmute, please? Oh, you just muted that. Do it again. Okay. Can you hear us?
Okay, yes, I can. Yes.
Very good. How are you doing?
I'm doing well.
Very good. You're in Rise Recovery at this time?
Yes.
Okay, you were supposed to be here today just because there was a $75 fine that was not paid. I'm going to waive it and close it. You're all set.
Okay, thank you, Your Honor.
I think that's all that. Okay, whose file do I have here? Dennis Dick. 26-116. That was for pretrial services. You say you had something that he did report?
Yeah, I seen it. She showed me on his phone. He called the number. I just don't know if anybody's got that.
Did you speak with pretrial services, sir?
Yes, ma'am. Well, Miss Emily just called me again today. And she said she did get my message and she was gonna, I told her I was here already. She said just once I finish this, she was gonna set me up. Because I didn't know I was supposed to call and check in. Or I often to call and check in. So I didn't.
Okay, let me cross the warrant and you'll continue your bond, okay? And check in with them like you're supposed to, okay?
Okay.
Do you have another matter?
No.
You're all set.
Thank you.
You're welcome.
Y'all have a good one.
Same to you. State of Michigan versus Anthony Rupp, 26-01073.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Good morning, Your Honor. Michael Puckett, student attorney requesting permission to practice pursuant to MCR 8.120 under the supervision of Lauren Sutter.
I believe she's.
I was gonna say, this is the first time all day I've not had a single public defender in here, but permission is granted. Can you spell your last name for us, please?
P-U-C-K-E-T-T.
Okay, and then we have Anthony Rupp present via Zoom. This was a retail fraud, second degree, and is there going to be a plea today?
Yes, that's my understanding. The people who made an offer.
Counsel, you can
to
approach.
Amend count 1 or add a count 2 of trespass, dismiss count 1, and the defendant was to pay
Restitution of 207.98, correct?
Yes, that is correct, Your Honor.
And Mr. Rupp, that's what you want to do?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am, I swear.
Okay, you can put your hand down, sir. You have the right in this matter to maintain your innocence. You're innocent until proven guilty. Do you understand that?
Yes, Your Honor.
You can take this matter to jury trial and require the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses that will testify on your behalf, the right to remain silent, and they can't use that to prove or imply that you're guilty. You understand each of those rights that you would need to give up today?
Yes, Your Honor.
Okay. And is anyone threatening you to get you to give those away?
No, Your Honor.
Any promises made to get you to waive these rights and plead guilty to the trespass?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that by pleading guilty, it could result in a conviction that you might need to report to your current employer.
Yes, Your Honor.
It also could have impact on where you can travel or get immigration status.
Yes, Your Honor.
As to trespass, how do you plead?
Guilty to the trespassing.
Okay, and then also you're agreeing to pay restitution to Target in the amount of $207.98.
Yes, and can't pay that all today, but I can make some of the payment and then get on a payment plan, or I'm not sure how that works, but I will, yes.
Actual basis.
Yes, ma'am.
Mr. Roof, is it true that on or about June 25th, 2025, you were present at 500 East Edgewood Boulevard, commonly known as Target?
Yes.
Is it true that that is in the city of Lansing, Ingham County, Michigan?
Yes.
And while inside Target, you were provided a written trespass letter by staff, correct?
Yes, sir.
And you've agreed to pay the restitution in the amount of $207.98.
Yes, sir.
Thank you. I believe that satisfies the fact basis.
For the underlying trespass charge, yes, the people are satisfied.
He was provided a trespass letter the day he was there.
Your Honor, that is our understanding, is that Mr. Roof he had signed a written trespass letter.
Okay, so he wasn't, was he notified prior to that he couldn't trespass?
No.
my understanding.
So are we eliciting a factual basis to we can only elicit to the underlying charge then, because if he wasn't notified prior to, it's not trespassing.
We can switch that line.
Yeah.
Mr. Roof, is it true that while you were in Target that day, that you tried to take or did take some property that was for sale?
Yes.
And you did so without paying for it?
Yes.
That was not accidental?
Yes.
Thank you, Your Honor. I think that satisfies the underlying charge.
People are satisfied.
Target was open to the public or for business at that time?
Yes.
Okay. I'll accept the plea to the underlying charge, except your, or the factual basis that is, to the underlying charge. I find your plea to be freely, voluntarily, and intelligently made. He's not on probation or anything, is he?
No, Your Honor.
I don't have a strong history. Can somebody bring up? Only reason why I hesitate to do immediate sentence is because the affidavit of probable cause mentions that he was a repeat offender at that location.
I think I can provide some information. Your Honor.
Yes.
So he'd never been previously charged for conduct. It looks like asset protection staff, in my reading of the report, had noted potential other things that they were keeping an eye on him for possible retail frauds in the past. They hadn't been able to confirm those and no charge had ever been issued. They issued the trespass letter that day. My understanding is there's been no occurrences there or anywhere else since then, but he was someone that they'd kept their eye on for a couple of business
Okay,
incidents.
so it was suspected.
Yes.
Prior to.
Yes.
But he doesn't have any prior convictions.
That's my understanding.
Yeah, I'm gonna double check. I think that that's factually accurate. I see no other.
Okay.
No other charges on the TCAs. I think that's why I was saying I offered the trespass.
No other. Okay, thank you. You can make out this counsel.
All right, Your Honor. We would ask for a fines and cost sentence. Mr. Ruth is working full time as a personal trainer. He's actually a business owner. He rents a booth at a local gym. He's had no bond violations while he's been on bond, and this has been going on for over a year now. We just spoke with Mr. Ruth briefly, and he takes accountability for what he did. He's expressed remorse. He's agreed to pay the restitution. So, due to all those facts, we would ask for a sentence of life.
Okay, there's a $75 crime victim rights fee plus a $50 state minimum cost plus the restitution of $207.98. So your total is $332.98. How much are you paying today, sir?
I can pay 50 to 100 and yeah, 50 to 100. I'll see if I can pay the 100 today.
Okay, when will you be able to make another payment after that?
The first of this next month, that's when I get paid on the first.
And how much is that?
How much will I be making? I'll try and take care of the rest. I'll try and have it completely covered by the first or on the first.
Okay, I'll note that you'll pay $50 today and then you'll pay the balance by June 1st. If you find out by the first that you need an extension, you have to request additional time, okay?
Yes, ma'am. Your Honor.
Any additional matters for the record?
Nothing further.
Nothing from the.
You're all set. We'll have some.
Thank you, Your Honor.
Thank you, Your Honor.
Because, I mean, we in the streets, we is in the street. This must be the other attorney. Yeah. Okay, what did I do with my screen? Something weird is happening. I don't understand. Oh boy. I don't know what happened. Darn it. Oh, well. Mr. Roof is all set. What's happening? How come when George comes in, it gets really loud? George,
Everybody knows.
George, clearly.
I'm sorry.
George the mayor.
Literally.
Lord help us. Okay, so this is the state of Michigan versus Karamjit Singh, 26-01170.
Thank you, Your Honor. May it please support Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Assistant Public Defender Jessica Stroud on behalf of Mr. Singh, who is approaching defense table.
Okay, Mr. Singh has a assault and battery set for today. How are we proceeding?
Your Honor, I believe I was supposed to have has not shown. So the people are asking that this matter be set for a final free trial.
No offer at this time?
No offer.
We do final free trial June 30th at 8 a.m.
June 30th, 8 a.m. in person at the court for final pretrial. So
Jury trial August 11th at 8 a.m.
August 11th, 8 a.m. for jury trial. Do you have any questions today? The additional matters for the record?
Nothing further.
Nothing from the people.
Thank you.
You're all set. Thank you. State of Michigan versus Jason Walker, 26-00866. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Mr. Walker is supposed to be represented by Mr. Blackman, correct? No? What happened with you getting Mr. Blackman to represent you?
Said if the victim don't show up, can we respectfully ask him to be thrown out?
Okay, so you want this set for a final pretrial? That's what you're asking for?
Jury trial?
Well, we will set up for a final pretrial first to see if the victim's going to appear. And then if the victim doesn't appear, you can request or make a motion to have the case dismissed. That's what you're asking for? Is there an offer at this time?
I believe 7649, 76.
Okay, let me get your final pretrial.
June 30th at 8 a.m.
June 30th at 8 a.m. Okay, you must appear in person. And then your jury trial, if this proceeds to jury trial.
August 11th at 8 a.m.
August 11th at 8 a.m. Okay. We'll get you a notice. Do you have any questions?
I was wondering, can I get my restrictions lifted on the tether? It's on Kreitz Road. That's where all the factories are. I can't work because the restrictions on my tether is blocking every factory on Kreitz Road. Bridgewater, Meyer Warehouse.
You want the tether restrictions lifted, you're asking for?
Yes, please.
Where do you work?
I was working at LG.
Where do you work now?
I'm unemployed because I can't get my factory job over there. So many restrictions.
You're unemployed because you can't get a factory job because of
I
restrictions?
don't want to work fast food or anything like that.
No, that's not what I'm
I can't
asking.
live off-
I didn't ask you, did I ask you why you didn't work for fast food? I'm trying to ask you what, you were working at LG and you lost that job because of your GPS tether?
Oh, no.
Oh, okay. Okay, so you have another option to employment right now?
Bridgewater.
Bridgewater, they've offered you a job?
Yes, I had an interview with them over the phone, but I can't go in person because it's in the restrictions.
Okay, because it's in the restriction or it's within the zone, 2,000 feet zone?
It's in the zone.
Okay. Are they asking for you to come for an in-person interview?
All right.
Okay. Will you provide me evidence that you got a job? I'm happy to remove the restrictions. I don't have a problem with that, but right now you don't have a job. So we don't need to remove it. You gotta bring me some evidence. Judge, I got this job, I gotta get there so that I can know how to fix it. I can't just fix it when I don't know where your job is. You see where we gotta go with that? So you can come back in here once you get a job, or even if you gotta have it adjusted for a interview. And then I can get with JSG so that we make sure that location is not within your exclusion zones, okay? We can adjust it for that purpose. But right now I don't have a way to do that because I don't know the location you need me to address it for. Do you have any questions at this time? Okay, so you get out there, you go find you gainful employment. And I should see you before June 30th because you're gonna have a job and you're gonna want your GPS tether adjusted.
I do have one question.
Yes.
Is there any way I can get in before June 30th or?
Yeah, today, I mean, it's June next week. And I don't think I have anything available on my docket prior to June 30th.
Okay, thank you.
Yeah, I definitely don't have anything available. So that's the best we can do. Thank you. So, did you need to speak to Jade Wiskowski?
No worries.
Okay.
I would, so maybe we can have.
Jade Wiskowski's the witness you said is here? No. Oh, okay, that's Benavides has a witness, I believe, or an attorney that's here, that's what it is. Person owes some money, is that what's going on? Okay, let's see, this is. Williams is in custody.
Hi.
Oh, okay. You must have had a new file or something, is that what happened? Yeah. Yeah. Jesus, help us, there's two. Okay. I go to what file? Well. Let's get that now. This is City of Lansing versus Sean Benavides, 26-01004.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney Dan Smith here on behalf of the people?
Good morning, Your Honor, to you and your staff, Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Benavides, who appears via Zoom. Mr. Benavides, can you state your full name for the judge?
Sean Benavides Jr.
Okay, this matter was scheduled for a dog at large pretrial. And was this matter able to be resolved?
No. Go ahead, defense counsel.
Okay, yeah, Your Honor, and in light of that, I don't believe it at this time there are any offers. I would ask for a final pretrial at this point in time, Your Honor.
Yeah. June 30th work for you at 8 a.m.
I'll make it work, Your Honor.
Okay, June 30th for final pre-trial at 8 a.m. We'll also get your jury trial date now. August 11th at 8 a.m. August 11th work for you?
Yes, it does, Your Honor.
That's at 8 a.m. In person at the court. Both.
I apologize, sir, I didn't mean to cut you off. And I was just wondering, as Is there any offer that is to be placed on the record today, just so I have it, just in case and can prepare properly?
Counsel,
No.
no offer.
Perfect. Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense either. I just hope brother counsel and yourself, Your Honor, have a great day. Great to see you guys, and I'll see you on June 30th.
Thank you. Have a good one. Where did Mr. Hardy go? No, Mr. Hardy. No, Mr. Straw, who represents Williams?
Who's Jessica or George?
Not George, because he's not in here anymore. Sorry for you for that. Jessica's good. George, this is my people.
I know.
We know. That's the problem. That's the problem. You never are. That's why you have to switch sides.
Exactly.
Are you ready on, you said, Wachowski?
Wiskowski.
This is the state of Michigan versus, let me go to the next page. Jay Wiskowski, 26-01140, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appear on behalf of the people.
Assistant Public Defender Joseph Hart on behalf of Ms. Wiskowski, who is appearing here via Zoom.
Okay, Ms. Wiskowski has a assault and battery pre-trial today. I'm assuming that we need to proceed to final pre-trial on this. Is
Yes,
that-
Your Honor. Yes, Your Honor.
No offer at this time.
No offer.
Final pre-trial July 7th at 8 a.m.
July 7th, 8 a.m. in person at the court for final pre-trial.
Jury trial August 11th at 8 a.m.
August 11th at 8 a.m. in person at the court for jury trial. Do you have any questions today, Ms. Wiskowski?
No, Your Honor.
Okay, any additional matters, counsel?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set, thank you. Do we have Leslie Buffington here? No? That's unfortunate, that's a licensing case. I see Veronica Bullard is here. Are you ready on her matter?
Yes, Your
This is State of Michigan versus Veronica Bullard, 26-01208. Ask them appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appear on behalf of the people.
Assistant Public Defender Justice Shaw, on behalf of Ms. Veronica Bullard, who is here remotely.
Ms. Bullard has a domestic violence pre-trial. Was there an offer at this point?
I don't believe that there was an offer at this time. No. Did I make an offer?
Well, I think you did.
Oh, well, if I make an offer.
I think there was a no objection to 769, but I don't think it goes hand in hand with the charge. Yeah, it's not a domestic violence charge, so.
What was it?
No objection to 769.
This is a domestic violence charge.
Is it?
Yes.
No, I think isn't this the one where,
Mom was gonna be here today.
Yeah, we were saying.
This is a domestic violence.
Well, Your Honor, we would like to set a final pre-trial.
July 7th at 8 a.m.
July 7th, 8 a.m. in person at the court.
Jury trial August 18th.
Jury trial will be August 18th, 8 a.m. in person at the court.
I think you're
July 7th?
Yes.
For final pre-trial and August 18th for trial.
Thank you.
No problem. Ms. Bullard, do you have any questions?
No.
Any additional matters?
nothing from the people, Your Honor.
Not from
Yeah,
defense.
this is the one.
Thank you, you're all set.
I do.
Thank you, Your Honor.
You're welcome. Did I just call? I called Buffington already.
Evaluation and treatment.
Michael Kern here? No?
Dr. Kern was not in the hallway. I've not seen him in the courtroom. I've left him several messages, Your Honor.
Which one goes? Oh, we have 3 files? Yeah. Paula Thornton here.
I see Paula Thornton in the hallway or in the courtroom, Your Honor. No, she's- I believe the phone was off. So I attempted.
Yeah, we should reach for her. That one. State of Michigan versus Jason Williams, 24-02588 and 25-02128. Here.
Your Honor, may I please report Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Assistant Public Defender Justice Rob on behalf of Jason Williams.
Not the same thickness. So that makes me believe they're not the same. Let's see. I could be wrong. Okay, I have bond violations. File number 24-02588. Williams drove to Envy's location and intimidated her with pepper spray.
Objection.
Objection? What are you objecting to? How many court TV shows have you watched?
No, I thought that's what you say when it's not true.
No.
Okay, I'm sorry.
And when did you see the defendant say anything? When did you ever see a defendant say objection?
I just had talked to her.
When did you ever see a defendant say objecting?
I don't be watching court shows.
If you're gonna have this many pending cases, you should probably start versing yourself in the procedure. You have an attorney here to represent you.
Okay,
She'll make the objections where needed. Objections are not because you don't believe it's true.
I'm sorry.
Okay, it's for an evidentiary thing, okay? So I have here an allegation in 24-02588. Why does it say that? Why it's tagged juvenile. There was a bond violation.
Yeah.
We definitely on the record. My goodness. Okay, there was a PA 53, which is what we called a conditional release from jail form. It said that you were not supposed to have contact directly or indirectly with an Indy Stitt Burton, that you're not to have or cause anyone to make any assaultive, harassing, intimidating. Ma'am, I am on the record conducting court.
Oh, I'm sorry. I apologize.
I understand there was a poor example demonstrated, which is why you thought that was acceptable. But I'm on the record, so you can't start blurting out. Everything that's stated in here has to be recorded. So now our record has 2 conversations going on that weren't supposed to happen in the middle of my record. Okay, back to you, sir. What I have here is a bond that says you're not supposed to have contact with this person and you can't be within 2,000 feet of wherever they are. There's an allegation that on or about May 25th at 1900 hours at the area of 2413 Fielding Drive in Lansing, that you made contact with the alleged victim, and she alleged that you were in a vehicle, a green Ford sedan, 10 deep. And that you exited the vehicle from the driver's side, approached the front yard, and pulled out pepper spray and began to spray the air while stating, "Come out here." And that would be in violation of your bond conditions. And file number 25-02128. The report is much thicker. I'm trying to figure out why. Okay. Also a bond violation alleging that you had contact with NB Stitt Burton. I believe it's the same report though. Maybe not. Okay, the allegations are again on or about May 25, which is again yesterday. The officers were dispatched to 900 Long Boulevard. In reference to a fight. And the allegations were that you followed Miss Stitt, Envy Stitt, and that you intentionally hit her with a white Chrysler. And that you collided with the driver's side door of her vehicle. Stitt stated that you hit the driver's side of her car door. And that you were trying to get her to come out of the vehicle, but she did not want to fight. She says that she's pregnant and does not fight because of that. This person. Say more than one victim. And who is Washington? Okay, they also spoke with a Demisa Washington on the scene who advised that her friend and the driver of the vehicle, Avani Stitt, this is gotta be one of the most written reports. Got in a mutual fight with Demia's sister, Demia Washington. Okay, so this alleged witness also alleged that you drove your vehicle into the side of Avani's Stitt's escape and was attempting to hit Avani. So you have the right in this matter to have contested hearings on both of these cases because they both would constitute bond violations. Your bond can be revoked on both. You could be sitting in jail pending ultimate resolution of either of these files. Do you understand that?
Okay, so
No,
you
no. Did you hear my question? What did I ask?
You said, do I understand that my bond could be revoked?
And so my question requires an answer. Did you answer that?
I do
Okay,
understand.
so no, you can't talk right now because I need to advise you of your rights. You have the right to remain silent. Anything that you say can be used against you. You can plead guilty to the violations or you can plead not guilty. We'll set it for a contested hearing. You understand your rights?
Yes, ma'am.
Okay. How does your client want to proceed on the violations?
He would like to contest them, Your Honor, so he's pleading not guilty.
Okay, so there's 3 counts of assault and battery on one file and the other one has another count of assault and battery. How are we proceeding on these? Was there an offer?
This attorney, so you're covering the files?
You're on GPS tether?
We are like to have this matter set for a final purchase.
No offer?
No offer. No.
So this is easy, because he's on GPS tether. We can easily find out where he was. So if he said he wasn't at 900 long, then his GPS will show that. If he said he wasn't at the other location, GPS tether will show that. Very easy. That's the point of the GPS tether. If I find out that you were there,
I did tell her I was there, but that I wasn't in contact with them. That's not what happened.
if I find out that you were where the alleged victims were, you're going to jail. You understand that? There's no reason up under the sun. How old are you?
I'm 20.
Right, a 20-year-old should be in here with 4 counts of assault and battery. Ain't nobody lying on you that many times. 4 different counts of assaultive actions. And then all of a sudden, everybody's lying about you violating the bond. You're on tether. We're gonna find out.
Yes, ma'am.
Okay? Counsel?
Your Honor, if this court would be amenable to a few minutes discussion with my client, I would like to talk.
You can have all the time you need to talk to, because we're setting this for final pre-trial in a bond violation hearing.
Well, it is on the matter whether or not we should contest.
He can decide if he wants to contest and tell us at the next court hearing. It's 11:42.
Okay, so the court would be amenable to us revoking the.
No, you can always enter the no contest plea at this time. That's what I'm saying. What I'm saying is, don't make me run no hearing just for me to find out you were there. Okay, that's what I'm talking about. You all can address that at another time. You'll have more time to counsel, because that might also help you figure out how you might want to resolve all of these matters. I don't know. Final pre-trial.
July 7th at 8 a.m.
July 7th, 8 a.m. That's also going to be the bond violation hearing. You must appear in person. Do you work?
Yes.
Where?
Wendy's and AutoZone.
You work that many jobs and you got time to pick up these many allegations.
It's allegations.
Because obviously they got them wrong, because you're too tired to do all of that. What's a good answer?
Jury trial, August 18th.
At jury trial, August 18th, also at 8 a.m. We'll get you notices to appear. You should be on tether on both of these, I believe. No, you're not. Only on the 2025.
Can I ask a question?
Yes.
Okay, so she said that that the JSG people were supposed to tell me a red zone or something, but they didn't. They only said just don't be within 2,000 feet or go the other way.
So you don't know where the restriction zone is, what you're saying?
No,
Did
ma'am.
your GPS tether go off at all?
No, ma'am.
Okay, so the tether is only going to go off if you're in the exclusion zone of where these people maybe live, work, or go to school. But you have a bond condition that you're not to be in contact directly or indirectly, and not to be within 2,000 feet of wherever they are.
Right.
So that has nothing to do with your GPS tether going off. And so if you are where they are, you have the duty to leave.
Right.
And retreat.
Yes.
And so what we have now are allegations, not just that you were where they were, but that there was assaultive actions and or that their vehicles were damaged because of it. And so that's easily verifiable because your GPS tether will tell us where you are, is what I'm suggesting. That's part of the reason why we put people on tether, so we can find out where they were. And so your attorney will talk to you in private about how you should best move forward, although we're setting these for hearings at this time, okay?
Yes, ma'am.
A bond at this time will continue with GPS tether. You are not to be engaging in any assaultive or threatening behavior. Do you understand that?
Yes, ma'am. And am I able to say that I could probably get a red zone map?
You have to call JSG for that. Yep, I would not have that. I don't even know where the victim lives. That information should have been provided to JSG, but I don't have that directly. And so that way, you can find out where the exclusion zones are. When you are in the exclusion zone, your GPS tether really should be notifying you or JSG.
Tether never went off until the police that came to my home and they were trying to find me and it started doing like a siren, but it never made any noise any other place. I'd be all over the city.
No, so that may mean that you were not in the exclusion zone, for all I know. I don't know. But that's how it works. And so you contact JSG, find out if you can get a map of the zone that you're not supposed to be in so that you can remain compliant.
Number is Googleable
for JSG, absolutely. But the concern is actually not that you were in the exclusion zone. Now, you're not being charged with being within the exclusion zone. You do recognize that, correct? The allegations are that you were where the victim was, not that it was within the exclusion zone. Okay?
So that I was aware
that you were in the location where they were. That's the allegation. And at least one of these allegations. It might be the thinner one. I don't know why this isn't this one. The address in this, I don't know if that is that person's, the victim's address. If it is, that needs to be provided to JSG. The Fielding address needs to be provided. Any additional matters?
Nothing from the people you're on.
Nothing, that's right.
Okay, you're all set. Thank you. That's all we have for the morning. Or what I did to this. Have a good one. What I did with this computer. Oh, there it goes.